G'day, class. We are going to proceed with our next topic to continue with the topics and discussions on elements of the state. We are going to proceed with the topic of sovereignty. Sovereignty. So, there are some provisions in the Constitution, as you can see on the screen, um, which mentions sovereignty there, particularly in Article 2, Sections 1, 3 and 7 of the Constitution. Specifically, section 1, the Philippines is a democratic and republican state. We've discussed this before. Sovereignty resides in the people and all government authority emanates from them. So, article or section 7, the state shall pursue an independent foreign policy in its relations with other states. The paramount consideration shall be national sovereignty, territorial integrity, national interest, and the right to self determination. Section 3 of the same article, civilian authority is at all times supreme over the military. The armed forces of the Philippines is the protector of the people and the state. Its goal is to secure the sovereignty of the state and the integrity of the national territory. So, but what do you mean by sovereignty? So, sovereignty by definition means supreme and uncontrollable power inherent in a state by which the state is governed. So, that's from Natura. So, basically, sovereignty is the capacity to enter relations with other states. So, a state's capacity to enter relations with other states. It is the supreme power to govern. It lies in the hands of the people, or the Filipino people, to be specific, who have the right to choose the type of government they want and to define the powers it shall hold and exercise. It is their right to abolish their government and form a new one and organize it in such a way or form such form as seems to them best for their welfare and happiness. So it is the supreme power, like what I said, and the final legal authority of the state to enforce its will on its members by coercive sanctions if it's necessary, which must not be subject to any like power. So sovereignty, if you talk about sovereignty, it can be exercised either directly or indirectly. So if we say indirectly, through public officials elected by the people. And if you notice, these elected officials can also appoint officials. Um, for example, the president has the power to appoint his or her cabinet members. Next is directly. So sovereignty is exercised directly through suffrage, of course, people's participation, direct people's participation through suffrage. We have the multi-party system, party list system, people's organization, system of initiative and referendum, and plebiscite, which we are going to discuss later on. So next would be the characteristics of sovereignty. So number one, permanence. So it's permanence or perpetuity. So it's a quality and virtue of which the state's sovereignty continues without interruption so long as the state itself exists. So those who exercise it may change, like what I discussed before previously, that administration change, but the state stays the same. The whole state may be reorganized, but the sovereignty, wherever located, persists. Only by the destruction of the state itself can sovereignty be destroyed. So it is perpetual. Next is exclusiveness. So the quality and virtue of which there can be the but one supreme power in the state, legally entitled to the inhabitants' obedience. To hold otherwise would be to deny the principle of the unity of the state and to admit the possibility of an imperium in imperio. Um, by the way, when we say imperium in imperio, it's actually a Latin term meaning to say empire within an empire. Next, we have the comprehensiveness or the universality. So, this is the universality of sovereignty within the state's territorial limits. That is, sovereign power extends over all persons, associations, and things within such territorial limits, except those over which the state has voluntarily consented to waive the exercise of its jurisdiction. So, just note that the state can or may waive the exercise of its jurisdiction. Next is absoluteness. So when we say absoluteness, there's no legal power within the state superior to it. So that it's already the superior. There's nothing that is um, superior or more superior than the state itself or the sovereignty. There can be no legal limit to the supreme lawmaking power of the state. Um, it is absolute. Its absoluteness. It is absolute in the sense of not being subject to any restraint, legal or otherwise. So nothing can stop it. It's superior. Its power is superior. In a civil society, although the laws passed by the sovereign are binding in all associations and citizens, still, this does not mean that there are no practical limitations. So, when I say absoluteness, of course, there are limitations, but although um, although there are practical limitations um, on the sovereignty of the state, although certain self imposed limitations, internal or external, cannot be legally treated as limitations. So there are practical limitations, but um, they cannot be legally treated as limitations. So still, it is superior, it is absolute. So these limitations are overcome by the absoluteness or the absolute nature of the state. Um, such as, for example, um, the concept of um, the power of the state, say, the eminent domain. Um, although although there are limitations to that power, such as it should be used for public purpose once the state want to, say, for example, take your property. It should be by law only for the purposes of public purpose, and uh, the private owner of the property uh, needs to be compensated in the form of just compensation as per the constitution. So although there are limitations or practical limitations, that is one great example that still the no one or nothing can stop the state from taking your property for public purposes, so long as those two requirements as provided by the constitution are um are are so long as those requirements under the constitution are fulfilled. So this is a great example of the absoluteness or the absolute nature of a state, that state cannot be stopped. If the state wants to take your property, for example, no one can stop it. Like I said, so long as it follows um, the requirements under the law, um, such as the purpose of taking is for public purposes, and that the private property owner is compensated through or via just compensation, then the requirements of the law is fulfilled, then the absoluteness or the absolute nature of the state still um, still overpowers the property rights of the private property owner. Next is the indivisibility. So there can be but one sovereign or sovereignty in a state. So there's only one sovereignty in a state. You cannot have two sovereignty. There's only one sovereignty in a state. To divide sovereignty is to destroy it. The exercise of its power may be distributed among various governmental organs, but sovereignty is a unit, just as the state is a unit. There must be there must be as many states as there are sovereignties. A divided sovereignty is a contradiction in terms. So just take note of that. Next is inalienability. So the state's attribute under which cannot cede it cannot cede away any of its essential elements without self-destruction. Like what I said, um, to divide it, to alienate it, um, would tantamount to self-destruction. Sovereignty is inalienable because it is the very essence of the state's personality, and its alienation would entail the disappearance of that personality. So, one state, one sovereignty, that is one personality. Sovereignty is the supreme power of the state, like what I said earlier on. It is the vital element of its being, and to alienate it would be tantamount to committing suicide. So it is as good as committing suicide. Next is imprescriptibility. Imprescriptibility. So no prescriptive period or time limitations, um, as sovereignty is perpetual, like what I discussed earlier on. So let's proceed to kinds of sovereignty. So there are kinds of sovereignty. Specifically, there are four of them. Um, First is the legal sovereignty, is the power to issue final commands. This is the supreme law making power. So legal meaning to say there is a law that provides for such power or authority, the power to issue final commands. Next is political, the power behind the legal sovereign, or the sum of all the influences that operate upon it. So influences, it's political. So this is legally unknown. So there is nothing um, in the statutes legally that explicitly provides for this one. Um, it is unknown, legally unknown, unorganized, and incapable of expressing the will of the state in the form of legal command. So, unlike the legal kind of state sovereignty, the political sovereignty um, does not derive from um, legal command, but it is this will that must ultimately prevail in a state. In a narrower sense, the electorate constitutes the political sovereign, and in a broader sense, the whole mass of population. So it goes back to election, goes back to suffrage. Um, so this, like what I said, is not found in any um, like there's no law that commands for it. So next is internal. So when you say internal, the power to control the state's domestic affairs. So internal, inside, so domestic. It empowers a state to make and alter its system of government and to regulate its private affairs, as well as the rights and relations of its citizens without any dictation, interference, or control on the part of any person or body or state outside the particular political community. So it is the power of the state to rule within its territory, in short. So next is external. So external, it is the power to direct relations with other states. So according to Bernas, SJ Introduction to Public International Law, 2009. Um, with this external type of sovereignty, the state is not subject to the control, dictation, or government of any other power. It implies the right and power to receive recognition as an independent power from other powers and to make treaties with them and on equal terms rather, make war or peace with them, send diplomatic agents if they want to other states, acquire territory by conquest or occupation, and otherwise to manifest the freedom and autonomy. So, in other words, the freedom of the state to carry out its activities without being subject to control by other state. So this is otherwise known as the independence type of sovereignty or independent or independence. It is important to note these some principles of sovereignty, um, like such as the effects of change in sovereignty. Political laws of the former sovereign, whether compatible or not with those of the new sovereign, are automatically abrogated unless they are expressly reenacted by affirmative act of their new sovereign. So they're automatically abandoned um, if the political laws of the new sovereign um, go against the political laws of the former sovereign, then they're automatically abandoned. So municipal laws or the domestic laws of the newly acquired territory, not in conflict with the laws of the new sovereign, continue in force without the express assent or affirmative of the conqueror. So case in point is Macaroila versus Asuncion AM number 133J, May 31, 1982. So effects of belligerent occupation. So when you say belligerent occupation, military occupation, that's example of that is a very good example of this one is the Japanese occupation in the Philippines. So that is an example of a belligerent occupation. So this principle is there is no change in sovereignty during a belligerent occupation. However, political laws except the law on treason are suspended. Municipal laws remain in force unless repealed by the belligerent occupants. So it's up to them if they want to retain the municipal laws or the domestic laws, then they can retain them unless they want to change them or repeal them. Like I said, there is no change in sovereignty during belligerent occupation. So next is the doctrine of use post liminium. So at the end of the belligerent occupation, when the occupant is ousted from the territory, such as what happened with the Japanese, the political laws which had been suspended during the occupation shall automatically become effective again. So, whatever political laws that were left or suspended um, before they came or during the occupation, then they will become effective again. It is important to um, it is important to note as well that there are also what we call as dominium, which is the capacity to own or acquire property, including lands held by the state in its proprietary capacity, um, according to the Supreme Court. And also the concept of imperium, which is the government authority, the supreme exclusive power, the right to command possessed by the state, which is appropriately embraced in the concept of sovereignty. Case in point is Lee Hong Kok versus David, GR number L30389, December 27, 1972. The state has territorial jurisdiction in connection with the concept of sovereignty. Territorial jurisdiction, which is the power of the state over persons and things within its territory. Exemptions Exempts are the foreign states, heads of state, diplomatic representatives, and consuls to a certain degree. Um, Foreign state property, including embassies, consulates, and public vessels engaged in non-commercial activities. Acts of state, foreign merchant vessels exercising the rights of innocent passage or individual or involuntary entry, such as arrival under stress. You have also foreign armies passing through or stationed in its territory with its permission, and such other persons or property, including organizations like the UN, over which it may be by agreement waive jurisdiction. So um, other than that, then the state has the power over the persons and things within its territory. So next would be personal jurisdiction. So that is the power of the state over its nationals, um, which may be exercised by the state even if the individuals is outside the territory of the state. So a very good example of that is the law on marriage, for example. So even if you're Filipino, even if you're outside the Philippine territory, the law on marriage still applies to you. Um, for example, in the case of um, annulment, a Filipino cannot um, remarry anyone um, outside the Philippines to anyone if that person is still not legally annulled in the Philippines. Um, it is by law, it's called the nationality rule, wherein the nationality law follows the person, the Filipino, wherever he or she goes, anywhere else in the world. So the Philippine laws is still law on marriage is still applicable for that individual. Next is the extraterritorial jurisdiction. So it is the power exercised by the state beyond its territory in the following cases. So first is assertion of its personal jurisdiction over its nationals abroad, as I discussed earlier on, under personal jurisdiction, or the exercise of its rights to punish certain offenses committed outside the territory against its nationals against its national interest, even if the offenders are non-resident aliens. Second is by virtue of its relations with the other states or territories, as when it establishes a colonial protectorate or a condominium or administers a trust territory or occupies enemy territory in the course of a war. So this is applicable in the course of a war. Um, Next is the when the local state waives its jurisdiction, like what I said, a state may waive its jurisdiction over persons and things within its territory, as when a foreign army stationed therein remains under the jurisdiction of the sending state. Um, so a very good example of this is, the VFA, Visiting Forces Agreement. I know you've heard the case of Pemberton, relating to the rape case and murder case of the transgender. In that case, the Philippine jurisdiction took the Philippine law, sorry, the Philippine government rather took jurisdiction over the person of Pemberton. But the note that the state may also waive its jurisdiction over the person. um, Even those, another example are those navy personnels that stop over at in Olongapo, for example, if they um, commit crime within the Philippine territory, then the Philippines may or may not um, take jurisdiction over the person of an accused, or may waive the jurisdiction, and and give the jurisdiction under the jurisdiction of the sending state, where the person, the state where the person or the accused, or the foreigner is coming from. Next is by the principle of extraterritoriality, as illustrated by the immunities of the head of state in a foreign country. Of course, the head of states are immune from suits as well, while they are serving as the head of state. Next is through enjoyment of easements or servitudes, such as the easement of innocent passage or arrival under stress. um, the an example for that, arrival under stress could be, those refugees that that just all of a sudden arrive in another country or another state, so that's arrival under stress. Next is the exercise of jurisdiction by the state in high seas over its vessels, over pirates, and the exercise of the right to visit and search, and under the doctrine of hot pursuit. So even if a vessel, for example, or an airplane or a aircraft, for example, um, is not in the Philippine physical territory, so long as, say, a crime happened inside the vessel, technically that is an extension of the Philippine territory. Hence, the Philippine government may take um, may assert its right over the jurisdiction over the accused, for example, if there is a crime happen in one of the Philippine government owned vessels. So next is the exercise of limited jurisdiction over the contiguous zone and the patrimonial sea to prevent infringement of its customs, fiscal, immigration, or sanitary regulations. So um, those are the extraterritorial jurisdiction um, examples where the state um, may has the power to exercise beyond its physical territory. So, in relation to the topic of sovereignty, it is important to note that there is what we call the principle of self determination in relation to statehood. Self determination is the right to independence for the people of non self governing territories and people subject to alien subjugation, domination, and exploitation. This is in accordance with the international law of the Unilateral Declaration of the Independence in respect of Kosovo Advisory Opinion ICJ reports 2010. So it is important to know the distinction between internal and external self determination. So when we talk about internal self determination, a people's pursuit of its political, economic, social, and cultural development within the framework of an existing state. So that is the pursuit of the people of its political, economic, and social and cultural development. So it is within um, or internal self determination. The whilst the external self determination is the establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence into any other political status freely determined by a people, constitute modes of implementing the right of self determination by that people. So please take note on that. So just to wrap it up, sovereignty means independence from outside or external power or control. The Montevideo Convention expresses this in a positive terms, such as including the capacity to enter into relations with other states. So independence as the fourth requirement of statehood. Remember, there's four elements of a state. Independence as the fourth requirement for statehood requires only the capacity to enter into international relations. The only aspect of freedom that is material is the capacity of a state to deal with other states, foreign affairs, or its foreign affairs, free from external restraints rather. Thus, what is important is that a state has the external appearance of capacity to enter into international relations. So that a state may be acting under the direction of another state is not of concern to international law. The practice of states has been to ignore, so far as the issue of statehood is concerned, various forms of political and emotional blackmail and interference directed against the weaker members of the community. So, like what I said, what is more important is the state has the capacity to enter into relations with other states. Um, in the eyes of the international law or international community rather, um, a state or that state is independent from any um, influences or outside influences. So um, I know I gave this as a part of your synchronous task discussion. um, how important is a state's capacity to enter relations with other states? I hope you'll be able to answer this. Um, an entity may, in fact, so the answer is an entity may, in fact, possess all the elements of a state, but if one or more states do not extend recognition to it, the entity would not be able to establish relations with those states. So, incidentally, although the Philippines was not yet an independent state in 1945, it was accepted as one of the original signatories of the United Nations Charter. It was one of the original member or signatories of the UN Charter. So that's so interesting. Even if it was not yet independent at that stage, but the world, in the eyes of the international community, it was already recognizing the Philippines as an independent state. So that ends our discussion regarding sovereignty. Next meeting, we are going to discuss incorporated government agencies and so as the Constitution if we still have time. So, thank you for listening.